And I did have another story about what are we doing and what can we do to stop union busting. But let's pop in and say hi to everybody. Hi everybody. All right, that's my better Harry Carey tonight. So we've got Gira, we got Les Bones, Luis is in the house. What's up? Anthony and Signs. And what's Anthony's out on the road. We got Yippers here. Hi Yipper and Jimmy. Who's got to burn it? What's going on? I don't know. I can't follow the chat. I'm going too far back. I just want to say hi to everybody. Happy Halloween. I think we're getting close. We're within about a half hour.
An hour.
Within an hour. Yes. I know how to count. We can do math. We have fun here. Okay, yep. So this is one of the last stories. I have two stories. So counter union busting. This is a quick one. How to win NLRB cases against union busters. That sounds interesting. And again, this comes from Labor Notes also, Phil Cohen. All right. Every labor dispute is a battle between hope and fear, is what he writes. And this is an interesting little cartoon that he includes. As big brands like Amazon, Starbucks, Chipotle lash back at worker organizing, union busting is getting long overdue exposure in the press. But while these stories graphically depict the problem, they don't offer any solutions. We talk about that a lot. Though many of the common tactics of union busting are illegal, there are only insignificant penalties that fail to discourage its lucrative practice. This is the only area of law where attorneys can advise clients to commit perjury in federal court without fear of disbarment or even censure. A union leader who understands leverage and human nature, though, can unmask their deception. I love seeing that, exposing corporate lies. Can I frame that? Right? Union busting on a plant-wide scale usually takes place under three circumstances: organizing drives, first contract negotiations, and attempts to decertify an existing local. We've seen all three of these things with ALU. The NLRB is a law enforcement agency created by Congress and President FDR in 1935 to protect the rights of workers to form unions and engage in union activity. It violates federal law for employers to interfere with those rights spelled out in the National Labor Relations Act. Okay, management is prohibited from threatening or coercing workers for union activity. It's illegal to show favoritism to anti-union employees while discriminating against pro-union employees. This is what the National Labor Relations Act says. Unfortunately, American labor law is filled with loopholes that are easy to exploit. So when employers wish to demolish an organizing drive or union local, they attempt to maintain the appearance of neutrality by using a select group of anti-union employees to carry out the dirty work. They often hire union-busting firms whose lawyers are experts at playing this game. Under our system of justice, everyone is innocent until proven guilty, including companies and the union busters they hire. It becomes the union's job to prove that management is pulling the strings. Sure. And here are some of the most common ways that companies engage in illegal union busting. Allowing antis free run of the plant during, that's anti-union employees, free run of the plant during work hours to criticize the union or circulate a petition to get rid of the union, legally referred to as free rein. The union's challenge is proving that the company knew and didn't take action. This requires multiple witnesses putting management on the scene. Management also talks with workers saying that they'd be better off without a union. We've seen that. Management coercing workers into signing a decertification petition. We see them try to do that. Threatening to close the plant if there's a union. We know that they've done that with Amazon, and we know that, of course, Starbucks has done that. Promising raises or other improvements if there's no union. And we know that Starbucks has famously done that and offered a two-tier wage system, saying that the problem is that they need to negotiate with the union to be able to raise the wages on the unionized employees. Interfering with the right to show union support in any way, so long as it doesn't interfere with production, including leaflet distribution at the plant gate or in the canteen. or wearing union stickers and t-shirts. The NLRB defines this as protected activity. And they definitely have stopped Amazon employees from wearing Union First or ALU badges or ALU clothing, threatening, firing, or disciplining workers for engaging in protected activity. They've definitely done that. Spooky skeletons. Okay, you gotta move that over a little bit. You gotta move that over to the right.
I'll work on it.
Okay.
God, you got a thing to do.
Yeah, they gotta immediately know. Well, you kind of distracted me there. You put it right in my field of vision. They immediately.
Sorry, I put it in studio mode. So.
Yeah, thanks. Notify the union at the first. Yeah, that doesn't work. At the first sign of these illegal activities, right? An experienced union rep or lawyer will file charges with the NLRB, but it becomes the job of local union officers and stewards to investigate within the workplace to gather evidence supporting the charges. Good luck with that. But when they're conducting an investigation, they should be considered covert operations. Management and antis should never be confronted about their violations. It only serves to make them more careful. Better for them to remain arrogant and feel above the law. I am above the law. Leading to mistakes that can be documented. If they're given a heads up about the union's efforts, management will keep committing the same violations, only being more discreet about it. So it's essential to understand what distinguishes evidence from hearsay or common knowledge. Everybody knows isn't evidence. We need to present witnesses to tell what they directly experienced. Somebody told me isn't evidence. It's hearsay. We need witnesses who personally saw or heard something illegal and will testify to it under oath. There are two types of evidence, cumulative and corroborative. It's best to have both. Cumulative is many people testifying about the same type of violation. Corroborative is the most powerful, several people testifying about the same incident, obviously. This is where the magical blend of organizing and legal tactics comes into play. Many potential witnesses will be frightened. That's the whole point of company tactics. Management targets people they consider weak links, but some end up feeling shamed and angry instead. First step is convincing each witness to meet privately with the union rep or lawyer. If their information is good, the union will then have to persuade the witness to provide a sworn affidavit to an NLRB agent. All the legal knowledge in the world is useless if one doesn't know how to talk to people and gain their trust. Yes. And witnesses have rights. Yep. So during this process, it's important to explain the protections granted by the NLRB to workers who testify. Affidavits are confidential. Agents are prohibited from revealing the identity of witnesses to management. They cannot be found out. I rat it out. The moment a worker sits down with an agent, they are no longer the union's witness. They become a witness of the U.S. government. The government doesn't like its witnesses being tampered with. It's a serious violation of federal law to discipline, fire, or even harass a worker for testifying. A big corporation may have lots of power, but the U.S. government has more. Yeah, tell that to our friend Matt Luttrell. While charges are being investigated, keep workers informed, boost morale, and discredit management. This in turn will inspire witnesses to come forward. Sure. Leaflet frequently. That's another thing they can do. They distribute union t-shirts and stickers. Ongoing shop floor presence of a labor dispute puts employers in awkward position with workers and lending institutions. The best way to keep people involved in a long-term campaign is to make it fun and entertaining. Humor is a powerful weapon. Poke fun at management and leaflets and cut the antis down to size. The antis being the anti-union workers that are siding with management, meaning we also call them bootlickers. Right. In situations where a union has been certified but is without a contract, another important aspect of employer violations kicks in: unilateral changes. And you know what? I do know there are situations and people that don't think that that being part of a union is what's best for them, their situation, their workplace, etc. And I respect that. I did not mean to poke fun by calling you all bootlickers. That's not my intent.
Yes, you did.
I'm talking about the people who rat out.
Yes, you did.
I'm talking about the narcs who rat out the union, the organizing employees. That's different, right? If you're one of those, fuck you. I got no problem saying that.
Yeah.
But in situations
AKA
where not just scabs, no, scabs are brought in to cross a picket line. I'm talking about current employees that are ratting on their fellow employees that are trying to organize to management so that management can start to screw with, penalize, retaliate against, or fire the people that are doing that. Okay? In situations where a union has been certified but is without a contract, like in the case of Amazon is about to be by NLRB, another important aspect of employer violations kicks in: unilateral changes. Under a contract, terms and conditions have been negotiated, including areas where the company can make routine changes. Without a contract, on the other hand, management remains frozen in the status quo. Every minor job change, temporary layoff, reduction in hours, etc., must be negotiated. Starbucks is currently ignoring that order. Employers, like he says, pay little attention to this, document each instance, as often it leads to major payback awards. One of the most fulfilling days of my career took place in the conference room of a textile mill in 1996 after an illegal decertification was shot down by the board. Management wasn't present as I handed out checks totaling more than $50,000 to workers who had been affected by unilateral changes over a 3-year period when the employer refused to bargain. Ow!
Kitty! It is a kitty, a spooky kitty.
So, presenting a good case backed by solid evidence isn't even enough. Most board agents are decent people who understand what's really taking place, but they're overworked, underpaid government employees who may take shortcuts and overlook some of the most important aspects of a charge. The NLRB needs to see the evidence through the union's eyes, and that requires knowing how to play the inside game. The union rep or attorney who filed the charges must meet regularly with the lead agent, follow up with briefs and position papers, and understand what's appropriate to go over the investigator when it's appropriate to go over the investigator's head to the U.S. attorney supervising the case or the board's regional director. You have to really fine line to walk. Now, if the union wins its case,
regional director,
right? The sub-regional managing, yeah, okay. Yes, the steam pipe distribution truncation a venue manager. So, if the union wins its case, when federal agents and attorneys feel the union has met its burden of proof, they issue a complaint against the company. It's the equivalent of indictment in a criminal case and will overturn any election tainted by management involvement. Okay, this is what happened in Bessemer, where they had to do a revote. Workers fired illegally will be reinstated with back pay, as happened with the Memphis 7 over at Starbucks. Employers can appeal this in a process that takes a couple of years. But if the union has a strong enough case, the employer will often make a business decision to cut its losses and negotiate. This usually happens when decertification attempts fail. Sometimes it happens during first contract campaigns too. Phil Cohen experienced this outcome at major corporations trying to decertify a local such as Mohawk Industries and Kmart, and during a first contract negotiations at a Serta mattress manufacturer. However, large companies that are being newly organized tend to milk the appeal process for all it's worth while committing new violations. Welcome to Amazon. This is where I hear what Amazon is doing. Don't buy into their efforts to break your spirit. Board charges give you a foundation for press coverage and to portray self-righteous management as the outlaws they are. Combine this with a solid organizing strategy, and there may come a tipping point when management realizes the ongoing campaign is hurting profits. Of course it is. Not only hurting profits, it's hurting their employees. Every labor dispute is a battle between hope and fear. Unions are at their best when we help people. Let me start that over. Unions are at their best when we help people find the courage to become their brothers and sisters' keepers. Union busters think they know human nature, but in fact, they understand only weakness and how to exploit them. They always underestimate what can't be accomplished by a group of workers whose higher instincts have been inspired. Never underestimate that a small group of people can change the world. And why would you say that? Because it's the only thing that ever has. And I hate to quote the shit livery of Aaron Sorkin and The West Wing, but that is one of my favorite scenes. And then the cheesy, God bless America. Fuck you, Bradley Whitford, for that nonsense. But that's a great scene. Cheese ball at the end, but really good. Bill Cohen, who is this guy? Yeah, he's also pretty big. He's been 30 years in the field in defeating professional union busters. So he speaks from experience on how to actually win. Ookie. You're Ookie. Actually, according to this, you're Ookie.
Ookie? Well, whatever.
Now you're Pookie. Well, you're New Jack. What up, Pookie?